But me nko ahomane so na me ne Mr. Edem said no enkodi enkomo emra wono co-chair edema the citizen movement against corruption na anope mene no eni enkomo. Mr. said no, if you can hear me, good morning and thanks so much for your time.
Good morning, thank you for having me.
Very well. So first off, the brouhaha between the office of the special prosecutor and then that of EOCO. I mean, what are we supposed to do as citizens of this country if these two major institutions that are presumably supposed to, fight against corruption, and then there ought to be some level of collaboration between the two in ensuring that we get to the finality of some of these matters. Yet they do not want to agree with each other in their line of duty.
Well, I think that citizens should pay attention to what the various mandates are, what the Office of the Special Prosecutor is required to do, and what EOCO is supposed to do. Understanding their roles will help a lot in matters like this.
Okay.
In this instance, the matter that the OSP had requested that EOCO look at is a matter of saying that, look, we found a lot of monies. Madam couldn't explain. Our law doesn't allow us to check money laundering, but because she couldn't explain the source of it, we believe there is some money laundering, and we want to investigate. Now, EOCO seems to be saying that, but the docket you supplied to us does not have the evidence of money laundering, which is a technical issue. It's technical because EOCO is required to investigate itself and establish the evidence. So if they are saying there's no evidence, it's almost like you went to court, as if they were the court and they have to receive the evidence. But that's not what the OSP is asking. OSP is saying, look, this is the little information I have gathered. In my information, witnesses have spoken. We are not able to reconcile her salary as a public officer and the huge hundreds of thousands of dollars found with her. She's not been able to explain. Okay. But we see that under your law, there's a section across that says that if we have an individual who is not able to explain the large disproportionate difference between the monies available or properties available and the income, that person is deemed to have committed a crime under your law. So we are handing it over to you because we think your law adequately covers this issue. It will take citizens actually understanding the two mandates to appreciate. I understand because I've looked at the two mandates. I'm clear in my mind that EOCO ought to have investigated first, not expect that the Office of the Special Prosecutor will give them all the evidence they need to just proceed. So that's the stage where we find ourselves.
Very well. Now, fortunately for us, yesterday you happened to be at the conference. I mean, the 14th Regional Conference of Heads of Anti-Corruption Agencies for Commonwealth Africa. Now, the question is that if EOCO truly has the mandate as part of their regulations or their laws, I mean, why is it that they are so much dependent on the fact that the Office of the Special Prosecutor will have to come out with the entire information, and then seemingly you have the Attorney General who is almost making same commentaries in support of EOCO's claim?
Well, it is unfortunate. I don't think this was an issue that should have gone to the Attorney General because EOCO has two mandates, investigation and prosecution. Investigation of matter is simply somebody has provided me a certain lead.
Okay.
Any citizen could have done that. That, look, based on the way I'm watching the things going on in this house, I think that there's some economic crime going on. And then I give you a few details that on this day I saw this come in, on that day I saw that car, and then at night around midnight I saw this. So I want you to check. Our investigative bodies on that lead are supposed to. That is enough to trigger an investigation. Now, investigation is not something that requires special advice. It is when you get to prosecution, when you want to be sure that in presenting before the court, you don't leave any leads or gaps that then the case will be thrown out. Then you go to the Attorney General. And their law says that when it gets to prosecution, they can consult the Attorney General. Attorney General. So it is strange for us that they haven't gotten to prosecution and we're going to the ages. Let me give you an example. Maybe this will help. It's like you have one group responsible for dealing with issues of stealing.
Okay.
That group must investigate, and then if necessary, they find something credible, they go to court and they'll prosecute. Then you have another group focused on murder. They are supposed to investigate, and if they find good leads, then they go to prosecution. Okay. So, let's say OSP is the murder group, and EOCO is the stealing group.
Yeah.
OSP is saying that we were investigating murder. But at the end of the day, we found no bodies. But as we were doing it, we found that certain sums of money had disappeared from this space. And the information we have clearly relates to stealing. So we are handing over the little information we have with the leads on stealing, so that you can start a case on stealing and also get to court. Then the group responsible for stealing writes to the group in response for murder and say, but we have not seen your full report on the murder. And the murder people are like, but you don't need that. What you need is the small information we give you that what we're investigating the murder, we found these 2-3 things that show that money has disappeared. And because your law covers stealing, we are saying, please investigate and then you go to prosecution. But the stealing people are saying, no. The evidence you provided is not enough. Meanwhile, you are supposed to investigate yourself. So there's a disconnect because even if they got the murder report, the murder report will not help them because they are responsible for stealing. So the request they are even making for the full investigative report from OSP doesn't make sense in terms of the logic of what is going on because investigation on murder will not contain anything that helps with dealing with stealing. And that's the problem. So I hope I have made it a bit clearer.
Yes, it's clear now. So what it means is that what the Office of the Special Prosecutor is asking of EOCO, I mean, is clearly within his mandate as an institution. So they ought not to be this kind of misunderstanding between the two institutions.
They are supposed to investigate. If what they are doing, and I worry because sometimes it has implications. They are past there. I'm sure from the high level to the low level, who will know that what some of the leaders are saying is only going to bring the institution into disrepute. Because that is your mandate under the law. It is clearly spelled out. It is almost like saying, I don't want to do my work. You should have done the investigation on stealing and brought me the evidence. But you are the one responsible for stealing. The other group is responsible for murders. The investigation they did was only on murders. And they know very well that if they bring a report to you, it is likely not to help you. What is relevant is witnesses who have given information about how the stealing happened or did not happen. And so they know that in the witness statements, you will find the evidence you need on hundreds of thousands of dollars and whatnot, which nobody has been able to explain. And they are saying, start with those witnesses and now establish that truly we called Madame Dapaah back because they gave Madame Dapaah a form to try and explain. She didn't. She never was able to. So they are saying, you look at the evidence from the witnesses, call her back and see whether she can explain. If she's able to explain, there's no problem. If she's not, then you know there's a credible case or likelihood of some money laundering or something having gone on. So it is surprising that EOCO is insisting. I am not too sure what they are up to, but for those of us who understand what the law is, this should not happen. EOCO should just do its job. In fact, if they had done some investigation and then told us that, we investigated this witness statement, that witness statement, and at the end of it, we still didn't get an explanation or she was able to explain, then all of us will know that they did their job. But until they do an investigation of their own, they should not make us think that the group responsible for investigating murder was supposed to give them the evidence for them to proceed. That doesn't work.
But do I equally get the impression that the OSP Act does not really give him the mandate to investigate issues bordering on money laundering?
That is actually the problem. It doesn't give them that act. It considers money laundering as an economic crime. Was pointed out. OSP was saying.
Can you hear me? Can you reposition for me? We're having a little bit of breaks in
Can
your
you hear me better
Yes,
now?
I can hear you better now.
Okay. So, yes, you are absolutely right. OSP is pointing out that, look, we've been handicapped because our law doesn't cover areas of money laundering, which would have allowed us. The only group in Ghana that has a law that covers this area is EOCO. In fact, EOCO's law is a good law because it puts the burden of proof on the individual. What it says is that if there's a disproportionate difference between the assets, properties, and monies of the person and their known income, and they can't explain it, the individual will be considered, shall be considered, it uses shall be considered as having committed a crime under our law. Very, very explicit, a very, very, very well-crafted sentence. The individual shall be considered as having committed a crime under our law, which means that the person is now responsible for explaining, not that the state has to find a reason before they take you to court. So if you took that case to court, the court will be reminded that the burden of proof is on the individual to show how they earn the money.
Exactly.
Once he has not been able to show it, the ruling will come. The challenge you have is so many other cases, they don't have that. In fact, that is why a lifestyle audit law would be good. Because in the U.S. and elsewhere, the burden of proof is put on that person who is fronting a lot of money, has properties. They will say, they can call you. If you cannot explain, they will confiscate the excess properties and money to the state. That law we don't have, and that's what they are also pointing out, that we really need that because it will help them. Their law is for them to deal with high-profile individuals. High-profile individuals have a lot of money, power, and influence. So every time they are finding ways to try and make it bad, try and frustrate their case, this one, for example, EOCO's law is clear. Unless somebody is trying to create a new, I don't know. And we already know that amongst the investigative bodies, when they are transferring cases, they don't go transferring it with reports. It always goes just with a docket. You can ask them. When EOCO sends a case to police, it is a docket with witness statements. If police sends to OSP, this is the standard across their industry.
They don't really go with the substantial evidence they've gathered.
They don't go with the report. They go with the evidence in terms of the witness statements. The evidence is the witness statement. But they don't go with a report because the report may be tainted with your biases. You understand? So what they want is the witnesses who spoke, the raw evidence. It's almost like if you went to 37, you had a medical condition. It became worse. And for some reason, they say, look, you have to transfer to Kolebu. If you get to Kolebu will ask you to repeat most of the key tests that were done by 37. They want to cross-check. It could be equipment failure. They will start some of the key processes again to assure themselves of whatever file you bring from 37. Then they will proceed to then do their additional investigation to draw a conclusion. That's exactly what we are talking about. You receive some information from the other agency. First, you have a responsibility to validate it. Then beyond that, you do your additional investigation to draw a conclusion. The reason why the report by itself was not what you use is that those who crafted that report could infiltrate it with their biases and prejudices on the people they spoke to or on the issues. So the safest thing is to use the raw one, start, build on it, and draw your conclusion. That's what is expected across the industry. That is a professional way. Because if you pick the report, and the report, they are focusing on murder. They didn't focusing on anything to do with stealing. And then all of a sudden you want to use that report to inform what you should do. That's not how it works. And all of us know that's not how it works.
Very well. But have you gotten the chance to listen to Samit Dapaah, the director in charge of communication and strategy at the Office of the Special Prosecutor? Now, he seeks to create the impression that there are some level of state-sponsored attacks against what they do as an institution. Do we necessarily get that impression, duly?
Well, my response since yesterday has been that they should expect that, and it should not be an issue that should be highlighted too much. I mean, it's the terrain. Your terrain determines what will happen. And we all know that corruption fights back. Corruption fights back. So, yes, the people involved will find ways and means to try and feed back. It may not only be media. They may find other ways also to frustrate. So, I don't think there's anything really surprising, shocking, or unique about the fact that these people will fund media or give money. If they have one or two friends in media, they'll call them and also tell them, no, this so and so and so and so. And that will not surprise at all. I think perhaps the OSP could have toned down that particular comment. For me, it is part of the terrain. They should be used to it. They can comment on it briefly, yes, but it should not be a surprising or shocking thing. That is corruption. People will try and find other comments, get people to influence your decision. They will do that because their livelihood is at stake. Their image and impression, so far they've been carrying themselves as well-to-do persons, so and so and so forth. And you're coming at them, they'll use some of those resources to try and hit back. There's nothing too surprising about that. I think the OSP should anticipate and just make sure that they are prepared for such situations.
But probably so they are equally speaking in that manner just to gain the public respect and sentiment, because, you know, Ghanaians do not have the patience, and a lot of us feel and think that, the OSP's office has not really lived up to expectation on its mandate.
Well, yes, I know people have been saying that, but, you know, this particular forum is a forum for heads of anti-corruption
agencies.
It was not supposed to be ordinarily an open session for Ghanaians or for the public. So there's a sense in which some of this information is more of how do we wrap our minds around this. If they had said this in the public space, then one would think that then your conclusion for me would have been valid. But as I assess this particular platform, it was intended for the heads of anti-corruption institutions as like we are sharing our experiences. And he had talked about achievements, and this was just, I think, in the challenges section, that this is one of the things that we face. And then the likelihood is other heads of institutions in asking their questions or giving feedback would then say, look, this is what we do, or this is how you can deal with it, etc. So I don't think it was out of place for them to mention something like this. Maybe, you know, don't forget OSP is pioneering, and some of the people there, this is the first time you're going down the road. And maybe some things that ought not to surprise you sometimes surprise you. I feel that in spite of the difficulties that OSP has faced, they are trying to do the best under the circumstances. Honestly, I look a lot at the anti-corruption fight, and if the OSP had not initiated certain moves.
Yes, I was actually going to ask you for your personal assessment and then your personal view on the work done so far by the office of the OSP. Now, you have followed this for a very long time, and so you will be in a better position to tell us if they are really, doing the work Ghanaians expect them to do.
In my honest opinion, I think so. I think that there are spaces where we haven't thought through processes well. And we need to do better. Let me give you an example. Yesterday, the Director General of the Anti-Corruption Commission in Zambia talked about how they have a law on the judicial side that says that no corruption case should go beyond 5 months.
Okay.
And I told myself, that's what we've been talking about. A fast-track anti-corruption court where nothing proceeds more than 6 months. And you train the judges, the prosecutors, the investigators in how they work together to get speedy results. That way, every 6 months, you have cases finished, you have people who have been penalized, they are out there in the public. It will serve as a good precedent. So I think about it and tell myself, look, we think we have our systems working. But I made that comment to Dr. yesterday that, seriously, our mechanisms don't seem to be effective in the large countries. The data that's provided, the small countries, Botswana, Seychelles, and the Caribbean countries, especially those 2 million to 3 million, not more than that, they seem to be doing very well. But the bigger countries, the data is not showing anything exciting. So somehow the mechanisms are working for the smaller countries, but the bigger ones not. The bigger ones, some of the innovative things are there. For example, that's a fast-track court system, which means that you have people trained for it. When you go there, it is not like the judge is a general judge and all cases. He doesn't understand the difficulties in the anti-corruption terrain, and he will raise this issue or raise that issue, and then they will allow the thing to go on. You know, so there's a sense in which I think that our judicial system and its design for now, as far as anti-corruption is concerned, is not tailored to be as effective to deliver the kind of speedy anti-corruption justice that we actually need in this country. And I think the OSP would have benefited from a system like that.
Yes, but I mean, we've heard stories about the fact that Ghana actually has one of the best laws when it comes to our quest in fighting against corruption. It is only the fact that institutions have not really lived up to expectation, and then the lack of political will is really what is causing us. So not necessarily our statute per se, but I mean how to implement. I mean how the Attorney General will be able to have the courage to, prosecute people even within his own government and also outside his government in that effect. Now, if we are unable to do all of this, how do we then get the best laws, yet we cannot be able to, get the required result out of it?
So you've raised, and let me separate it into 3 issues. There's the issue of laws. It is true that to a large extent we have some of the very best laws across the continent. We have at the moment 2 or 3 major gaps. One of those major gaps is illicit enrichment or lifestyle audit law.
Okay.
Because if it were there, OSP would have used that in this case, the Cecilia Dapaah case, but it wasn't there. So that is a major gap. We don't have illicit enrichment. Most other jurisdictions have that. There's also the gap of the Code of Public Officers, Conduct of Public Officers Bill, something that is specific to putting together all the issues relating to public officers, which has been hanging, I think, at the presidency for quite some months now. That too we don't have. Outside that, we have a lot of good laws, but the laws must lead to people being taken to court, and we are saying that our court system at the moment is not designed for effective, efficient delivery on anti-corruption.
Okay. Because
our anti-corruption cases, if you track them over the years, they take forever, and most of the time we are not getting the result that we would expect. So the court systems need to be more efficient in terms of the speed, and we need to do more training between the prosecution and the judicial part of it to ensure that those 2 arms are in sync so that the prosecutors know what the judges are expecting. The judges are giving feedback to improve the prosecution so that cases that come before it, we are not wasting time, people running around, and we don't deliver a result that actually shows that we are fighting corruption.
Yes, but just to wrap up with you, at the starting point is the asset declaration law, where, people going into public offices are required by law to declare their assets. How well have we been able to utilize that aspect of our law?
Oh, that's one of the laws that is not fit for purpose. Even though we have that law, it's not fit for purpose. Even in Nigeria, they do a public declaration. You can go online and find people's names and their properties there, and you can punch holes. If you want to punch holes, you can go online, see it, and punch holes. Here we say put an envelope, seal the envelope, and then you need a special permission to have the envelope opened up. It's absolutely not fit for purpose. And that's one of the things that if we were serious, the government of the day would have led the process to have it reviewed and corrected long time. And that is where our political class ought to know that, look, citizens are watching. That is a place where, together with media, we need to put this political season. We need to be demanding of the presidential and other candidates what you will be doing about assets. If you are coming into office in the next 8 to 9 months, what is your intention on asset declaration? Can you make a commitment now? That is the way to get a better fit-for-purpose law in that space.
Very well. Mr. I'm highly grateful for your time this morning.
And thank you for having me.
Thank you so much. Mr. Edem Seneno, co-chair at the Citizens Movement Against Corruption, speaking to